We do have quorum, honorable senators, and therefore we proceed with the business of the afternoon. Clerk, kindly call the first order.
Order number 1, communication from the chair.
Now, before we adjourn for lunch, the counsel for the governor had 10 minutes to respond to the submissions made by the county assembly. So, counsel for governor, you may now proceed to utilize your 10 minutes in response to the submissions that have been made by the county assembly.
Thank you, Mr. Speaker, sir, for the opportunity. I'm here to do a very brief rejoinder based on the submissions done by the counsel for the county assembly. And I begin by stating, Mr. Speaker, sir, that the County Assembly of Isiolo has, to a greater extent, misunderstood our PO. The extent of that PO, the nature and the effect of that PO. I say that because when we start to listen to the responses, all counsel appearing took the position that we were telling this Honorable Senate that it has no jurisdiction to entertain this matter. That is not the nature of our PO. We all agree that there is no court order that can bar or gag this Senate from entertaining a motion for impeachment of a governor. That one is not in any disagreement. But, Honorable Senators, our PO is based on the fact that there is nothing in law that has been brought before you for consideration to invoke your powers under Section 33 and Article 181 of the Constitution. Because for the Senate to sit to discharge that mandate, there has to be a valid motion of impeachment. Our simple request to the Senate is that there has been no valid or competent motion that has been forwarded to you to warrant your interrogation of the same. Why? For 2 reasons. That motion that has purportedly been brought before you is a motion that the court had killed before it got to you. So there is no motion. Secondly, the law anticipates that you will sit here to listen to a resolution that has been passed by a house constituted under the standing orders. Our argument has been simple. The Isiolo County Assembly did not sit to deliberate on the impeachment of the governor of Isiolo County. So then, what would you be sitting to listen to? Because Section 33 and Article 181 gives this House powers to hear whether charges against the governor have been substantiated. So it presupposes that once you begin the trial, you are actually listening to the actual charges, actual violations, actual counts that the governor is being accused of. So once we cross this bridge, we'll not be looking at technicalities. We'll only be addressing ourselves to the charges that the governor is being accused of. Honorable Senators, a month ago, a young man was brutally murdered. And the police presented a dead body of that young man, Albert Ojwang, to Mbagathi Hospital, expecting that the hospital was going to admit that dead body and treat that dead body. Mbagathi Hospital stood their ground and said, our duty is simple, to treat patients. What you're bringing here is not a patient known by nature or in medical terms. He's dead, not even on arrival, but was dead before even arrival. That is the same thing the County Assembly is doing, bringing you a dead body in the name of a dead motion and expecting you to invoke your powers under Article 181 and Section 33. We dare submit, Honorable Senators, that is not even a dead motion. This motion is stillbirth. It never got to be born. Why? Because it was never debated and it was never resolved to impeach the governor of Isiolo County. Honorable Senators, when you look at the arguments by the County Assembly, They are telling you that we need to go to trial to establish whether the Hansards that we took time to impeach communicate of a house having sat. Now, what witness is being brought before the Senate to address you on things that are clear? Documents speak for themselves. The answers that we took time to take you through are not our documents. They are not documents hinged on an affidavit. They are documents supplied by the county assembly. None of the council who appeared before you took time to address you on any issues that we address you on to suggest that there is no way a sitting could have taken place. So do you then call a witness here to come and address you on issues that are glaring, that are very obvious on the face of it? It would be a total waste of your time, honorable senators. There has been also an attempt by the county assembly to portray the governor of Isiolo County as a person who advances a self-defeating argument just because it is seen that he approached the High Court to impeach this process. It has been said that the governor acknowledged that proceedings took place. Nothing can be further from the truth. Honorable senators, the honorable governor of Isiolo County went to the High Court in Isiolo based on a press release by the Speaker of Isiolo County purporting to communicate a resolution to remove him from office. A press release that was not backed by any other evidence that indeed there were proceedings that took place. Honorable senators, you will not come across any broadcast of the proceedings that are said to have taken place on 26th of June, 2026. Nothing. Not from mainstream media, not from local media, nothing. The only communication that the governor got was a press release that the county speaker had just to demonstrate that there were proceedings that took place. And therefore, honorable senators, we urge you to invoke your powers. I stood here last year in October, representing the County Assembly of Kericho. A question arose as to the propriety of that motion. Debate was held here. And I stood to defend the position that proceed and hear the charges on merit, and if there is any question on the propriety of that motion, deal with it at that juncture. Honorable senators, I remember the words of distinguished Senator for Kakamega, Boni Kawale. He told me, and I quote, Mr. Mutuma, he called me by name, what do you want the governor to prove? What do you want the governor to prove? That same question is the same question I expect honorable distinguished senator today to ask. Are you inviting the governor to prove that indeed there were proceedings that took place? It was the duty of the county assembly, before they even started submitting, to establish that indeed a sitting took place. There is only one way to demonstrate that, by providing this house with credible answers. And documents, honorable senators, speak for themselves. We do not need a witness to take the witness stand to interpret answers. Answers are supposed to communicate what transpired verbatim without the need of calling a witness to explain. Their own answers, honorable senators, do not demonstrate a likelihood of a sitting having taken place. And therefore, just the same way you set precedents, because this is a house of precedents, that your mandate under Article 33 and 181 encompasses the right to, first of all, interrogate prima facie whether that motion has met that threshold. And that's exactly what we're inviting you to do. If you find that the answers and the documents on record do not support the existence of a valid motion, you do not need to proceed to the next stage. Because once we proceed to the next stage, there is only one duty left for you, to look at the charges on merit and establish whether the governor is guilty or not of the charges that have been preferred against him. I rest my case. Thank you, Honorable Senators.
Thank you. Now, Honorable Senators, we will move to clarifications for half an hour. If you get an opportunity to seek for clarification, kindly keep it under 2 minutes so that we can hear a number of you. Now, as you take to the floor to seek your clarifications, kindly indicate from whom you're seeking that clarification. So we're going to do that for half an hour, and thereafter I will give 15 minutes to the team, to the governor's team, and 15 minutes to the county assembly team to respond to the clarification that will have been addressed to them. The Honorable Senator Cheriot, the Majority Leader.
Mr. Speaker, this is a very complex matter, but simple at the same time. I'm struggling as I read the documents from the Assembly and the response from the Governor to establish who is a clerk in the County Assembly of Isiolo. If you read the sworn affidavits from the County Assembly, and I have the two documents here, there's a gentleman quoted who confirms that indeed there was a sitting. The response from the Governor also has a gentleman insisting that he's a clerk for the County Assembly, and he insists that there was no sitting. I'd wish to hear from both councils on who between these two gentlemen is a clerk of the Assembly, and as at the time when they swore these affidavits that are before us, was that the position at that particular time? Because maybe there's a difference in time or whatever. But just to help my mind become clear as I seek to unravel the truth, Mr. Speaker, I'd wish to establish that. I thank you.
Senator Manzo.
Thank you, Mr. Speaker, for giving me an opportunity to seek clarification. I would like to seek clarification for the advocates of the County Assembly that when I listened to the preliminary objection and the answers the councils gave, and they are very brilliant councils, I know, and I had an opportunity to appear with them in court. What is your rebuttal? Out of the points given, could you point out your rebuttals, 1, 2, 3, so that we can know what points? Otherwise, for me, I just had a big lecture, and I didn't pick out the rebuttal points. I thank you, Mr. Speaker.
Senator Karungo.
Thank you very much, Mr. Speaker. My clarification is, I do understand every house has Hansard. In most cases, like at the Senate, we have video recordings. So do we have the same for the county of Isiolo? Have they submitted the Hansard, the audio Hansard, plus the video Hansard for that day? So that goes to the county assembly and probably also to the governor. And the next question to the governor now, on that day that the governor was invited to appear at 9 a.m., did he appear at that particular time? Thank you, Chair.
Senator Professor Tom Ojenda.
Thank you, Mr. Speaker. I would wish to seek a few clarifications from Counsel on both sides. Let me start with the Counsel for the Governor, and I will ask Counsel Elisha Ongoya this question. Counsel, your preliminary objection is premised, one, that there is no motion because there were no sittings on the 18th and 26 June 2025. I want you to go straight to address the Senate on the affidavits that have been sworn in support of the fact that there were no sittings. Were there sittings? Were there assembly proceedings? And this I ask because the response from the assembly is not clear as to whether or not there are sittings. Mr. Nyamodi, perhaps this is to you to clarify as well. You said that the sittings on the 18th and 26th informed the basis for orders obtained from the High Court in Meru before Judge Nyaga, and that the doctrine of estoppel should apply to the governor's team, that they cannot approbate and reprobate at the same time. Now, please give us a response. Was there a sitting? Was there or was there no sitting? Because that does not answer that word. Number two, to the
Senator Mungatana.
Well, thank you, Mr. Speaker, for giving me the opportunity to seek a clarification. Mr. Speaker, I just wanted to hear counsel for the County Assembly. There is a question that has arisen about the High Court sitting in Meru that nullified the decision that was taken through a motion. I wanted to know if they took time to appeal that decision, to seek a stay in that decision, or whether that decision of the High Court is still holding firm. And if so, what does it mean then for the arguments? Mr. Speaker, I submit.
Senator Osochi.
Mr. Speaker, I want to direct my question to the Counsel for the Governor, and this is based on the affidavit by Counsel Deuri, where he has stated that there was no sitting. Mr. Speaker, I find this to be a very fundamental issue in this case, which will determine the direction that this matter will take. But I would want him to weigh that against the provision of Article 159, 2 of the Constitution. This is in regard to the judicial authority, where it says, in exercising judicial authority, the courts and tribunal shall be guided by the following principles. Most importantly, the principle D, that justice shall be administered without undue regard to procedural technicalities. Does this sit in on this principle, considering that having a sitting at a gazetted place is a very fundamental issue that this House will consider?
Senator Fernande Chiranke.
Thank you, Mr. Speaker. One is I wanted to find out from the County Assembly whether your proceedings are live streamed or do you have a YouTube channel where we can refer to. Number two, Speaker, to the County Assembly again, I've seen the affidavit of a clerk. How many clerks do you have? And if so, do you have gazette notice? Because when you look at Standing Order 65 of Isiolo County Assembly Standing Orders, there is a procedure of impeachment. Number five, to Ongoya. We have already disregarded the issue of conservatory orders as a House. What is the difference between conservatory orders and this High Court decision? Number four, finally, Mr. Speaker, I saw there were presence of army or purported in the County Assembly chambers or outside. Who invited them to the County Assembly and who was the clerk then? And finally, when you conducted the public participation, Did you disregard the court order that was in place? I submit, Mr. Speaker, sir.
Senator Enoch.
Thank you, Mr. Speaker. Mine is to the Counsel for the Assembly. Two quick issues. The Speaker, the answered, that is the official record of debates and proceedings in any legislative body. And you have attached a copy of the answered in your report. Is that the official record? On record, is that the official record? Because the Speaker, then if it is, then perhaps what the answer is in Isiolo is probably different from what we know it. So address us on the issue of the answered. And secondly, the Speaker, the motion that the court in Meru pronounced itself on, is it the very same motion that is here before us? Or is there any alterations to that motion? Is it the same motion that the court in Meru pronounced itself on? I thank you, Mr. Speaker.
Senator Sigay.
Thank you, Mr. Speaker. My question, or rather clarification, is to Counsel for the Governor. This is with regards to the validity of the motion that is before the House. You have, this is directly to my senior counsel, Ongwaya. The motion before the Senate, you've said, must be solid, valid, and meets the threshold. Other than the decision or determination from the court as to the validity of the motion before the Assembly, is there any other deficiency in the motion that is before this House? Because you have made reference to the precedent set by this House in the Kericho impeachment motion, and at page 147 of volume 4, you will note that the validity of the motion before the House was not one of the three issues that the Speaker in his determination highlighted as subjects that were to be determined at the preliminary stage, or rather at this stage. And secondly, to Counsel Nyamodi for the County Assembly, could you please speak to this aspect in validity of the motion of impeachment, where you have said it has got no effects on the proceedings that is before the House, if I got you right, because there wasn't any rebuttal on that particular submission from your end. Thank you, Mr. Speaker.
Senator Momo.
Thank you, Honorable Speaker. My question is to the Counsel for the County Assembly, again on the Hansard. Is the Hansard that you have provided an abridged version or the verbatim provision of a Hansard? Secondly, do you have an audio version of this Hansard?
Senator Boni.
Thank you. Thank you, Mr. Speaker. Mr. Speaker, mine is to the County Assembly attorneys. My brother Nyamodi, I've listened to you, I've listened to your four other colleagues, and none of you has attempted to respond to the grave allegation that the documents purported to be the Hansard are cooked documents. None of you has tried to tell us that they are not. Is it your position that the documents before us here from you are cooked as alleged by Counsel from the County Assembly, from the Governor's office? Secondly, and last, Mr. Speaker, I want to draw the attention of Mr. Nyamodi to page 23 of volume 4 of the governor's response, where the governor's advocates are reminding us what the court said. The court said that they do not wish to stop us from listening to this matter. However, the court pricked our conscience, and they told us in bullet 24 that the matter at hand calls for a stand to be taken by constitutional organs involved. What they choose to do will have set a precedent on the necessity for compliance with court orders. And concluded by saying it will be a choice between anarchy and constitutionalism. Counsel Ongoya is
Senator Murango. Senator Mundigi.
Asante Bwana Spika, swali langu ni kwa advocate wa MCS. Sheria inasema wakati wa impeachment watu wanafaa waende public participation. Advocate wa governor wanasema public participation haikufanyika njia ile inafaa. Naomba advocate wa MCS ako na hasand ama kidhibitisho ya kuonyesha kama wako na wondi 20 walifanya public participation wondi ngapi, kwa sababu iko katika sheria. Na wakati walifanya wanaweza ako na kidhibitisho ya kuonyesha kama iko na hasand ama ni watu tu wali. Bwana Speaker.
Senator Mundigi. Yale mambo ambayo yamezungumzwa na mawakili kutoka upande wa bunge la county ya Isiolo na upande wa governor, hayo ndio mambo unashurutishwa uulize kiwa una tashishi yoyote. Usichukue mambo ambayo haikujadiliwa na haijatoka kwa county assembly ama kwa upande wa governor uzungumzie. Ni yale peke yake ambayo yamezungumziwa ndio unaweza pengine ukiwa una tashishi unaweza kuuliza ili ifafanuliwe zaidi.
Bwana Speaker, hata hiyo swali langu nauliza linafanana na ile majibu alikuwa na jibu.
Senator Kavindu.
Mr. Speaker, my clarification I'm seeking from the county government of Isiolo. When they stood to defend or to talk against this motion, I did not hear them clarify beyond reasonable doubt about the meeting, if there was a sitting on the 18th and on the 26th of June. 2, Mr. Speaker, I want to get a clarification from the lawyers if it will be in order or right for this Senate to go against court order. Thank you, Mr. Speaker.
Senator Karen Nyamu.
I want to clarify I want to seek clarification from the advocate of the county assembly of what the all the procedures met. Was there a quorum? Was there a notice given to the MCAs of this sitting? Was the governor given due notice? Just to try and establish if all the procedural rules that appertain to this kind of motion were met.
Senator Omtata.
Honorable Speaker, thank you for the opportunity. I would like to clarify from the councils for the County Assembly whether or not there was a court order issued against the proceedings that eventually resulted in the impeachment that is before us for trial. So whether there was a court order or there was no court order. Thank you, Mr. Speaker.
Senator Methu.
Thank you very much, Mr. Speaker. My clarification, I want to seek a clarification from the team from the County Assembly. There has been a fundamental issue that has been raised by the councils for the governor that the Isiolo County Assembly did not sit, and they have gone ahead to give us reasons why they believe that the County Assembly did not sit. I have not heard in your rebuttal an attempt to prove to this House that the County Assembly of Isiolo actually sat, because that is an extremely fundamental issue, because the Council for the Governor has gone ahead to say that then if there was no sitting of the County Assembly, then there is no motion before this House. That would be an extremely fundamental issue that we must get to understand, especially from the County Assembly, whether indeed there was a sitting of the County Assembly on this particular matter.
Senator Peris Tobiko.
Speaker, that was actually the question, but I want to ask it directly. Can they confirm and they should...
If it's already been asked, Honorable Senator.
Speaker, let me put it differently. And just to remind them that they were under oath. And they must confirm if there was a sitting on the 26th of the County Assembly of Isiolo.
Now, Honorable Senator, the advocates are not under oath because there are no witnesses in this matter. Senator Mofire.
Thank you, Honorable Speaker. My concern was preempted by Senator Bonalola and Senator Manso, because my concern was I listened to the charges.
So it's already been preempted.
Yeah, but
I
thought I could make some further clarification.
No. Senator S.C. Okenyuri.
We are repeating ourselves.
Thank you, Mr. Speaker. I would wish to seek clarity from the council representing the County Assembly whether the Hansard recording, which is now in doubt, was conducted in the County Assembly or outside. Thank you.
Senator Kenywa.
Mr. Speaker, my issues are raised by Senator Manzo.
Senator Morango. Well, now, Honorable Senators, we shall now move to from the two teams, starting with the County Assembly. Now, I had already indicated the time available to you. 15 minutes to the team from the County Assembly and 15 minutes for the governor's team. You may proceed, Counsel.
Thank you very much, Mr. Speaker. I want to start from the top, Senator Cheruiyot. You are correct. This matter is as complex as it is simple. Who is the clerk? Is it the clerk who swears an affidavit in the governor's statement? Is it the clerk who swears an affidavit in support of the impeachment motion? Mr. Speaker, it is the position of the County Assembly that the governor captured the clerk. That is a matter of evidence, and that is evidence that we want to lead. When I said we want to cross-examine the clerk, it will become apparent when you listen to that testimony that the governor captured the clerk, and the clerk, for all intents and purposes, became a saboteur to the impeachment proceedings. You will see in the governor's clerk statement, a statement where the clerk says, I cancelled the public participation. So that is what I meant. It is important that the Senate enables this motion to get to the point where the evidence is laid before you, and you can then make up your determination about what happened, who captured who did not capture who. And it is the Assembly's position that the governor cannot capture the clerk and then hold the clerk and say, because there was no clerk, there can be no impeachment. It is apparent in law. You cannot do things like that and seek to benefit from them. So therefore, this motion must then get to the point where evidence is laid. Senator Manzo, what is our rebuttal to the points given? I had stated that a preliminary objection is, in our humble understanding, an issue of law that is raised. There are several factual rebuttals, but we as counsel, in the privileged position we occupy, are unable to testify. Our witnesses have rebutted those things that counsel have said, and it is therefore vitally important that this motion gets to the point where the Senate can hear that testimony from the witnesses themselves. We say, yes, there were sittings that took place, and we have said further that from the conduct of the governor who took those proceedings to court, they acknowledge that the assembly did take place. There is an affidavit from a senior superintendent of police in Isiolo who says that he went and the proceedings in the assembly were disrupted. Surely the Senate must hear from that superintendent of police. We have cross-examination to put to him so that you make up your mind about what happened in those proceedings, who sabotaged, who took place, who took part, and so that you can make up your mind. Yes, it is complex and simple at the same time. Senator Karungo, do we have audio and video of the Hansard of the day? I will allow my colleague to respond to that question. Senator Ojenda, Senior Counsel. Sittings were the basis of the orders obtained in Meru. Yes, we allege that there is an estoppel. Was there a sitting? Yes, there was a sitting, and that is why there is Hansard that the governor's advocates seek to now criticize at the preliminary stage. If there were no sittings, there would be no Hansard. And if there were no sittings, there would then be no foundation for the governor's advocates to go to court in Meru on the 25th or the 26th of June and get the orders that they did. That those orders exist from where we sit is proof that those sittings took place. Senator Mungatana, has the Meru decision been appealed or stayed? Our position is that in respect of impeachment proceedings, the Supreme Court in the Martin Nyaga Wambora matter gave guidance, not just to courts below, but to county assemblies and to the Senate, as to what to do with orders that are issued, like the ones that were issued by the High Court in Meru, in respect of incomplete impeachment proceedings. Those orders, according to the decision of the Supreme Court in Martin Nyaga Wambora, can be, I think the wording used by the Supreme Court is that they cannot be, they should not then be immediately effected. And that is the guidance that has been given by the Supreme Court. Senator Cheralgei, how many clerks? I believe I have attempted to answer that question. Yes, there is a question as to how many clerks there were and who was the clerk, but that is a matter of evidence. They have their position about who the clerk was. We have our position about who the clerk was. As I have said, it is our thesis that they captured the clerk. But the assembly needed to continue, and that is a matter of evidence that will then need to be tabled. As an advocate, I am unable to testify to it, but I know those affidavits exist in the record. Who invited the army? Like I said, in the governor's documents, there is an affidavit by a senior superintendent of police, and it is apparent that if he is swearing an affidavit for the governor, then the answer as to who invited the police or the army is answered by the fact of who is the police or the army testifying in favor of. Was public participation done? Yes, public participation was done. Was public participation done in disregard of the court order? I want the answer that I have given in respect of Senator Mungatana's question as to what should be dealt with court orders of the nature or of the species of, that was issued in Meru in respect of these impeachment proceedings to also apply to this, to that issue. Senator Wambua, is this the official Hansard of the recording proceedings? I will say yes, but my colleague Mr. Mawira will come and deal with that issue in more detail, and he will explain to this House as to why those are the official Hansard reports in respect of the proceedings. Senator Sigei, the ruling of the motion was the ruling that the motion was of no effect. Is that the motion before this House? Yes, it is. And I would urge this House then to consider that ruling in respect or together with the ruling of the Supreme Court or the guidance of the Supreme Court as to what should be done with rulings of that nature. And if I may state during my response to the questions from the senators, if this House stops this impeachment proceeding in respect of a court order like the one that has been issued, then as an advocate who has practiced law for not an insignificant time, I can say without any fear of contradiction that this is the last impeachment that this House will do, because the court orders will delay and delay and delay. There is a good reason why the Supreme Court took the position it did in Martin Nyaga Wambora, and there is no reason to depart from that position. There was a question as to whether the Hansard is full or abridged. Do we have an audio recording? Again, my colleague, Mr. Mawira, will respond to that. Senator Halwale, no response to the allegation that the documents were cooked. That is an issue of fact. And because it is an issue of fact, it cannot fall from the mouth of the advocate that the documents were cooked. That can only come from a witness. And from our corner, it can only come from our witnesses. That is their position. We have an answer. And it is in the response, or it is in the documents that are brought in support of the motion. It is not an issue, because it is an issue of fact, it is not an issue that can be brought forward and tried as a preliminary issue, as the legal team for the governor seeks to invite this House to do. That is an issue, and it is a contested issue in the motion, and I beseech this House to allow the motion to get to the point where those who are competent and capable to testify to those contested facts are able to do it. In respect of the order, or in respect of the finding, Senator Halwale, again at page 23 of volume 4, again I will repeat my answer to that question. This is an order, the species of which was envisaged by the Supreme Court in Martin Nyaga Wambora. Compliance does not need to take place, it doesn't need to take place immediately, and the Supreme Court then is clear that such an order, when issued by the High Court, should not and cannot get in the way of impeachment proceedings. The High Court's jurisdiction only arises once the impeachment proceeding is complete. When I was on my feet earlier on, I made the statement that what the Supreme Court envisages is an instance where even where the impeaching House is making a mistake, allow them to complete the mistake, because that is how institutions grow. And that is why the Supreme Court held as they did. Again, I will emphasize that these are time-bound proceedings, and if we then expose ourselves to the judicial process, we will never finish. Senator Mudama, clarify if there were sittings on the 18th and the 25th of June 2025. Yes, and that is the only way that the motion could have gotten to the Senate. My colleague will demonstrate by reference to the Hansard in the evidence in support of the motion when and how those proceedings took place. Would it be in order for the Senate to proceed against a court order? Mr. Speaker, I will ask to perhaps add a word in the question that was put to us by Senator Mudama. Will it be in order for the Senate to proceed against an unlawful court order? We have gone to great lengths to demonstrate that that order is unlawful, it is made without jurisdiction, and it is made in circumstances where it is clear, and there are binding pronouncements both of the Court of Appeal and of the Supreme Court that that court disregarded, that that court's jurisdiction only arises upon the completion of the impeachment proceedings. Those proceedings have not been completed, and that order is therefore to be ignored. I cede the rest of my time to my learned colleague so that he can cover the other important issues.
Honorable Speaker, my name is Moreno Boniface Mavera. On the first question by the majority leader, on who is the clerk of the assembly at the moment, from the Salad Boru's affidavit, the clerk of the assembly, he has sworn an affidavit in support of the governor, in support of the governor's case. From his own affidavit, he confirms that he was sent on leave on 16th of June. He was sent on compulsory leave on 16th of June of 2025. The court suspended the decision, sending him on compulsory leave on 1st of July 2025. The motion that is before you was tabled on 18th of June when the clerk was on leave. It was debated on 26th of June of 2025, still again when the clerk was on leave. Therefore, the clerk cannot be a witness of fact as to what transpired in the assembly on these 2 days when the motion was tabled and when it was debated, because he was on compulsory leave. He only resumed after the court, the Employment and Labor Relations Court, granted him interim relief on 1st of July. On the question by Senator Karungo, the video and audio Hansard has not been filed. It was not anticipated by the assembly at the time of filing his documents that the governor would be challenging whether there was a sitting. But I have just been informed by the speaker that he has an audio recording, the assembly has an audio recording of the Hansard. So if it is required, it shall be filed with the office of the clerk. I have checked the rules, Honorable Speaker. The rules do not provide for filing of additional documents after documents have been exchanged between parties on Friday, when we came and served the office of the clerk with the documents for the respective parties. So if it is required, the audio recording of the answer, it shall be provided. On the question by Senator Muma on whether there is a social media site for the assembly, there is no social media site for the assembly proceedings. So there is no record, either on YouTube or on the assembly sittings that day. For other previous proceedings, if there is members of the press who are allowed in the chamber, there are proceedings for those days. But on this specific day, there was violence. And as I was saying, Honorable Speaker, this is a matter of evidence. If you go to our volume 1, you will find an OB report on page 42. This OB is on the breaking in on the county assembly on the date of the debate. And with your leave, Honorable Speaker, I would request that our video number 6 be played. That video will demonstrate that the entire Hansard of the county assembly was vandalized on the 26th of June 2025 when these proceedings, when the debate on the motion was ongoing, and therefore the county assembly, Honorable Speaker, all the records, including the Hansard of 18th, were stolen. What is more curious, Honorable Speaker, from our video number 9 in our folder, is that the only office in the entire county assembly that was spared is the office of the clerk. And this clerk is a witness for the governor. On the question by Senator Nyamu, whether the governor was invited, it is indeed true. On our volume number 5, page 5 of that volume, that is a letter of invitation sent to the governor. It was served, and an affidavit of service is filed in that regard. On the last question by Senator Umtata, whether on the effect of that court order, a court order that is given by a court lacking in jurisdiction, as my senior said, is a nullity in law. It is of no legal consequence, to borrow the words by the governor's lawyers. On the question by Senator Mundigi, indeed public participation was undertaken. We have 2 volumes, volume 4A and volume 4B on that question. Honorable Speaker, I would request your indulgence for time to have those 2 videos played. They're crucial to this question of whether indeed the assembly sat, because it demonstrates the violence and the vandalism that took place in the assembly on the 26th of June. In that regard, I would request for maybe additional time to play those 2 videos.
Counsel for the Governor, there's a request that has been put forth by the Counsel for the County Assembly to play a certain video in proof that indeed the sittings took place.
Thank you, Mr. Speaker. May I seek your indulgence to understand the issue? Do I understand the request by the County Assembly Council to be that a video can be played here which will show that the sitting took place? Because if that is the request they are making, then they can play it. We see where that sitting took place. We'll also be glad to see it ourselves.
Now, Counsel for the County Assembly, it is your case. The question that is before you, there has been an assertion from the team of the governor that no sittings took place. Now, you've decided to play a video in response to that allegation. Is that video going to show us a sitting taking place? Or is it a video showing us a sitting never took place because of certain reasons?
Honorable Speaker, that video, as I've already stated, due to the unique circumstances, the proceedings of that day, the vandalism, the violence, the mayhem, in the Assembly precincts on 26th of June, the video we're about to play is not a video of the sitting of the Assembly. It is a video showing the entire destruction of the Hansard office in the County Assembly.
No, Honorable Senators. Honorable Senators, again, I'm going to say it. It is your case. If that video proves that the conditions were such that a sitting could not take place, how is it going to aid your case? But it is your case. You can proceed. Let the council play his... Yes, Senator Omtata, what is your clarification?
I thought we were handling a preliminary objection. We cannot begin examining evidence. Otherwise,
Senator Omtata.
Yes, Your Honor.
I hear you. Just take your seat. The clarifications that have been sought here is for the County Assembly to indeed confirm that a sitting took place. I think several senators rose to seek that clarification. In response to that, the County Assembly has requested to play a video.
Just to say, it's a question of evidence that is contested, and that's what we need to know. If it's a question of evidence contested, then we shall deal with the evidence when we get there. If we begin looking at the evidence now, I would rather we just deal with matters of law, which are matters of preliminary objection, and they had argued it well, and they had said it's a matter of evidence. And if that's the case, that's a matter of evidence, then what's the fate of the PO?
Very well, Honorable Senator. You will make that decision when you debate and vote on the motion. Just hear what the County Assembly wants to show you. It is upon you, using that same line of argument, to either take it or leave it when the time for making decision arrives. You may proceed.
Honorable Speaker, the video we are about to play, and I'm responding to the concern that was raised, is not to demonstrate that the circumstances were that it was not possible to hold a sitting. Our position is that there was a sitting of the Assembly. However, due to the violence and the disruption, as even the, and I don't want to go to affidavits, Honorable Speaker, because that's a matter of evidence, as Senator Mtata submits. The circumstances after that sitting were that the Hansard report was vandalized, and that is why, Honorable Speaker, as we came to Senate and as we exchanged documents, the answer that was filed was not a recording of the actual sitting of the Assembly. The answer was vandalized after the sitting. So, Honorable Speaker, with your leave, if the Assembly can be allowed to, that audio recording...
Honorable Senators, kindly view the recording and make a decision at a time when you're supposed to make your decision. Proceed.
Jigi in the boardroom, hakuna kitu ndani boardroom. Boardroom imesafirishwa.
And also video number 9 that shows the office of the clerk.
The clerk, anaiko sawa. The clerk, anaiko sawa.
Those are the two videos, Honorable Speaker. My final comment on that issue, Honorable Speaker, is that this violence and mayhem at the Assembly was perpetrated by the governor. We will be calling witnesses and lead them in evidence in support of that submission. And, Honorable Speaker, it cannot be that the governor perpetrates such violence and ultimately is the beneficiary of his own violence. He cannot benefit from his own mischief, Honorable Speaker. That is the entire point we are making, and that was the importance of showing those two videos. And finally, Honorable Speaker, can I get directions on whether that the audio Hansard can be filed with the office of the clerk? The Speaker just availed it to me.
Absolutely. It will be considered when making the decision on this preliminary matter.
I'm most obliged, Honorable Speaker.
Counsel for the Governor, you may proceed. You have 15 minutes to make your rebuttal.
Thank you, Mr. Speaker. May I have a sight of my time? I will take 7 minutes, and my learned colleague, Mr. Theuri, will take 8 minutes. For the record, my name is Elisha Ongoya. Allow me to start with the question raised by the Leader of Majority of this House on who is the clerk of the County Assembly of Isiolo. In answer to that question, Mr. Nyamodi answered, what happened to the clerk? So giving a simple and straightforward answer, who is the clerk? The simple and straightforward answer is to be found in the County Assembly's own documents, volume 5, at page 8. The County Assembly has attached as part of its evidence a document signed by the clerk. That is Salad Boru Guracha. So that is the simple and straightforward answer to that question. Distinguished senators, every time you ask a question and people have to scatter around it for 5 minutes, a question that requires a name of a person, it is manifest evidence there is a problem with that team. Number 2, to the question raised by Senator Ojienda, directly to me, on the question of the affidavits, whether the County Assembly in fact sat, the following affidavits of the following deponents show that the County Assembly did not sit on 18th of June 2025, when this motion is said to have been introduced in the House, and on 26th of June 2025, when this motion is purported to have been approved. Number one is the affidavit of Salad Boru Guracha, the clerk. Senators, you will know the role of the clerk in the business of the House, and is a person likely to know whether the House sat or not in two respects. Number one, when he is physically present, and number two, as the custodian of the official records of the House. He says by reference to both records, either by physical presence or by reference to records of the House, where he is the sole custodian, the House didn't sit. Number two is Abdinur Dima Jilo, the MCA for Kina Ward, a member of the County Assembly. By virtue of being a member of the County Assembly, he's a person who can know when the Assembly has sat or not. And number three, the affidavit of Diba Abdirashid Ali, the leader of majority in the County Assembly of Isiolo. That is a member of the House Business Committee who is likely to know, number one, whether this business was ever scheduled for that day or for those days for this House, and whether the House in fact sat and transacted that business. Each of these crucial witnesses bring before you evidence that the House did not sit on 18th of June 2025, when the Assembly rather did not sit on 18th of June 2025, when this motion is said to have been introduced, and on 26th of June 2025, when this motion is said to have been approved. Allow me to move to the next question by Senator Mungatana on whether the decision from Meru, my apologies, there's one more affidavit I overlooked, my decision, don't tweet, my apologies for that. There's the affidavit of Shaban Mzungu, the superintendent of police. He was the person in charge of security at this important public installation, the County Assembly premises, which also houses the county governor. So it's the county government premises in Isiolo. He also confirms that there was no business transacted in the House on that day because of the circumstances to which he deponds to in his affidavit. The question raised by Senator Mungatana on whether there has been an attempt to appeal that decision and whether the decision still holds. Now, this is also another very simple and straightforward question, because an appeal is a particular act. And I expect the senior counsel, Mr. Nyamodi, to respond more directly to this question. I had him to answer what is the effect of this decision. Senator Mungatana, the simple and straightforward answer to this question is that not even a notice of appeal, forget about the appeal itself, has been lodged in respect of this decision. Not even a notice of appeal. So, not only has the County Assembly not appealed this decision, they have not even shown an intention to appeal, which is normally signaled by a notice of appeal. To the question raised by Senator Cherargei, my answer is as follows. This was not a conservatory order. This House has historically had issued the conservatory orders granted ex parte. The order we have here is an order granted after hearing both parties. In fact, when you look at the record of the ruling of the court narrates the order of events, the Assembly lawyers were even given time to go to their clients and take instructions and come back and address themselves. So this was an order made after hearing both parties to the dispute, and this is what distinguishes this from the other conservatory orders that this House has had occasion to deal with in the past. Senator Wambua asks us another straightforward question. Is the motion we are dealing with in this House the same motion that the court dealt with in Meru? Senator Wambua, the simple and straightforward answer is this: yes. it is the same motion that the court declared null and void and of no effect. Senator Sigei asks an important question about validity of this motion. Senator Sigei, our answer is as follows. The deficiency of this motion is on multiple grounds, broadly two. One, there is an order of court declaring it null and void. And when it's declared null and void, it is not a valid motion. Number two, it is a piece of paper, as I told you earlier. It is a piece of paper because even for this House, this distinguished Senate, for a motion to be said to be a motion, it must go through the procedures known to the Constitution and the standing orders, be voted upon, and be a resultant motion. It cannot be proper, even for this House, for the Speaker and a few members to sit somewhere outside this House, craft material that look like Hansard, and say this is a motion. So it becomes invalid. And the video that has just been played and the submission of Counsel prior to playing that video confirms this more than ever before. Counsel says that the Hansard was completely vandalized and therefore they could not produce a Hansard, which begs the question, the material they have presented before you purporting to be Hansards, where did they get them from? That is not a legitimate origin of a valid motion of a House. Senator Kavindu, you raised an important question. Is it right for the Senate to go against an order of court? Court orders generally involve two disputants, whether it is in a public interest matter like this, a matrimonial case, whatever case it is, it involves two disputants. It is never right for any person to disregard a court order with abandon. We are all consumers of legal judicial services one way or another. And on that day when we get a court order in our favor, we desire a country where that order means something. And therefore, that will be my answer to your question. To Senator Karen Nyamu, whether all the procedural steps were met, no. Procedural steps were not met. The motion was not tabled. The motion was not debated. The question was not put. There was no sitting of an assembly. And therefore, there could have been no resultant motion underpinning this, whatever has been brought before you. Allow me, in the interest of time, to then invite my learned colleague, Mr. Eric Teuri, to continue with the responses to the various questions. And thank you for your audience.
Honorable Speaker, I would take maybe a minute or two in view of the very substantive responses that have come from my colleague, Mr. Ongoya. I think the only question I have is one that was posed by Senator Karungo. At the time when the governor was invited, he was in his office, and at 9 a.m. or at no time was there a sitting, and so there was no way that the governor could attend any sitting because none was held. There was a question that was posed by Senator Osotsi with regards to Article 159 of the Constitution, and my answer to you is that the question we are raising is not one of technicalities. It goes to the root of the dispute that is before the Senate. There must be a resolution, and in the absence of a resolution, the jurisdiction of the Senate has not been properly invoked. And so therefore it is not a technical, procedural issue that can be cured by Article 159, subsection 2, but rather it goes into the question of the merit and whether the authority of the Senate has been properly invoked, and we have submitted that that has not happened. I think those perhaps are just the only questions that had not been responded to and posed to our side. But, honorable senators, let me just remind you that the question with regards to the sitting is one that is extremely critical, and our position still remains that there was no valid sitting of the 18th or the 26th, and that is abundantly clear when you listen to the responses that are coming from the Assembly. You do not know on which side of the mouth they are speaking from. In one instance, the Hansard was destroyed. In another instance, the Hansard is a true record of the reflection of the proceedings that were held in the House. And so that question is the question that we have submitted on, and we urge this Honorable Senate to find that there are no proceedings known in law, and so therefore there cannot be a resolution that has been presented to this Honorable Senate to deliberate on. I rest.
If I may, Honorable Speaker, with your leave, Honorable Speaker, I request to clarify something that Ongoya Counsel has misquoted me. With respect to the audio.
If you go that route, we'll never come to the end of this matter.
It's just one clarification.
You may proceed.
Honorable Speaker, what I said was stolen is the video Hansard of 26th. The audio recording of the proceedings of that day is available, and that is what we request your leave, Honorable Speaker, to file with the Office of the Clerk. The audio recording of the proceedings of 26th is available. With respect to 18th, Honorable Speaker, the audio recording was stolen when the Hansard was, that room was vandalized on 26th, but it is after that audio had been introduced into the Hansard that is now on the floor in our documents. That is the clarification I wanted to make. Thank you, Honorable Speaker.
Now, Honorable Senators, having concluded the hearing of the preliminary issues raised, now pursuant to Standing Order 38, as read together with Standing Order number 1, for the convenience of the Senate, I hereby suspend the sitting for 30 minutes to allow for the preparation and circulation of a supplementary order paper that will enable the Senate to make a fair and just determination on the issues that have been raised. You may rise.
Well, that is the directive by the Speaker, a suspension of 30 minutes to allow for the circulation of supplementary order paper. This suspension of the House for 30 minutes, the House will, after 30 minutes, resume these sittings where senators will be voting whether to continue with the hearing of the impeachment matter before the House, or the other option is whether they'll be agreeing with the Counsel for the Governor that indeed the preliminary objections raised before the Senate this afternoon and in the morning do hold water. And in the event that the senators vote to agree with the Counsel for the Governor, the matter ends there. But in the event that they do not agree with that appeal by the Defense Counsel, then the House proceeds to hear the matter fully before determining it on the 10th. So, as the Speaker walks out of the chamber, closely followed by the members of the Senate, allow me to take you back to the Broadcasting House for our normal programming. We'll be